Hello and welcome to this masterclass on commercial property. My name is Tom Owen. I'm a barrister at Keating Chambers in London. We will be discussing 3 recent decisions and their practical implications in the following fields. First, pre-contractual representations and duties of care. Second, agents' duties. And finally, guarantees. Sophisticated commercial property transactions often include express provisions which seek to regulate the content of the agreement which the parties ultimately enter into. And they often contain express provisions seeking to regulate the reliance which parties have placed or not on pre-contractual representations and negotiations. But those provisions are not always effective, they are not always included in commercial property deals, and sometimes they do not achieve the intended effect. There's another aspect of this that I'd like to talk about, which is special purpose vehicles, or SPVs. SPVs are often used to finance or to enter into property deals, either as principals in their own right or as agents acting on behalf of other parties. It is this interplay between the special purpose vehicles and pre-contractual representations that I'd like to discuss, and the case that I'd like to highlight is the recent decision of the Supreme Court in Cremasso LLP and Ogle v Grant. The principal issue for the Supreme Court in this case was whether a party to a commercial property deal, in making a negligent misrepresentation to the agent of the party which ultimately entered into the deal, whether the person who made the misrepresentation owed a duty of care in tort to the counterparty which had not been in legal existence at the time when the misrepresentation was made. It is commonplace in commercial property transactions that agents who are retained on behalf of the vendor can often be involved in sourcing purchasers and can, in certain circumstances, be engaged by the purchaser in relation to the deal itself, so that essentially they are acting on behalf of both parties. Clearly that raises great difficulties as to conflict of interests and whether or not that agent is acting in breach of those tortious contractual and equitable duties. The case that I'd like to highlight in this regard is the Northampton Regional Livestock Centre Company against Mr. Cowling and Mr. Lawrence. This case concerned relevant agents' duties, in particular claims for breach of contract, for breach of fiduciary duty and in negligence against an agent who is retained by the vendor of property but who subsequently became involved on behalf of the purchaser. Lawyers spend a lot of time looking at how guarantors can avoid paying a claim which is made under a guarantee, and also pre-contract advising the funder or the developer or the landlord, whoever has the benefit of the guarantee, as to the pitfalls to avoid to ensure that that guarantee is enforceable if a claim is made under it. In that regard, the case I'd like to discuss today is Topland Portfolio and Smith's News Limited. The principal issue in this case was whether or not the defendant, who was a guarantor of an insolvent lessee of premises, was liable to the claimant, who was the claimant freehold owner, of a claim under a guarantee. In particular, the court had to consider the rule in Home and Brunskill. For me, the overriding feature that arises out of all of those is the absolute need for full disclosure at all times between the parties as to any matters which may have significant legal effect going forward, as to the enforceability of the agreement or as to the appearance of there being pre-contractual representations which can be relied on to later avoid an agreement. Full disclosure is key. Get all the parties involved and get all of the relevant information put down in writing.